The other trick that they use is they say, well, since you weren't working before or making a salary, quote unquote, then therefore you have no loss of earnings in the future. And that is simply not the law of the state of Texas. The law of the state of Texas says if you have a capacity to earn income, if you have a capacity to work, even if you chose not to work before the injury, you can still recover those damages. So understand, and I want all your viewers to understand, that if they ever get into a litigation or a problem, and they may not have a high amount of earnings in the past that they can point to, if they have the capacity to learn, the skills, the education, they must be compensated, and they should discuss that with their good trial lawyers.
And remember, ladies and gentlemen out there, this does not constitute legal advice. We are talking about this because it is very important for the citizens of Texas and also the nation and worldwide to learn about our legal system. Now that we're on YouTube and you're listening to Charles Houssiere, an experienced trial lawyer with over 30 years experience in the legal field, and he's done medical malpractice, and let's take advantage of that. I want to ask you a question. Let's break it down for those people. A person comes in, their mother's dead because she was starved, beaten, not given the proper care in a nursing home because of low staffing, and other guests that we've had on say that the system is really gone awry, and negative outcomes are fueling more profits. Okay, so they don't have staffing. This person was abused. The daughter, 50-year-old, comes in frantic, and you know this scenario every day. And you think the case has merit, but let's backtrack. How do you just, somebody comes through the door, you do the interview and decide which cases have merit and file, and then kind of walk us through the anatomy of a lawsuit, what to expect? I think a lot of people don't understand medical malpractice and how it works.
Sure. Well, first of all, you have to understand that when you come into a law firm like ours and you want to discuss the most intimate details of your life and injury, a loved one that has died, or a mother or father in a nursing home that has been abused and not taken care of like they should have, you don't really know what you're in for. You don't know, how am I going to pay for this? How am I going to handle this? A few lawyers across the state of Texas, like myself, are willing to take these cases on what is known as a contingency fee basis. Without a contingency fee, people simply cannot afford the hourly rate of lawyers. Believe it or not, those lawyers also advance the costs of litigation for court reporters, experts, filing fees, etc. In the case. So if one has a case, feel good about the fact that our trial lawyers across the state of Texas are still willing to do that in meritorious litigation. The next thing you have to understand is does the case have sufficient enough damages to expend the type of time and expenses on the case in order to result in a recovery in the case. Today, we have these limits that we talked about for pain, suffering, and mental anguish, disability, disfigurement, and so forth of $250,000. You might not realize that a claim in a nursing home is actually a medical malpractice claim and governed by that act, and therefore you're limited by that. So you want to come in and talk to your lawyer about what has happened, what type of suffering people have gone through, what type of pain, how have the doctors treated that pain and disability, and so forth. The next thing you want to do is you want to tell them about any sort of lost earnings or earning capacity, as we've discussed, or medical bills. Bring in any records that you have received. Keep them close at hand, because unfortunately I have learned that sometimes records go missing and are lost. So if you have records from your loved ones or from yourself, please keep them and bring them into the attorney's office. Once you've come in with that information, there will be an initial discussion with the attorney. He will advise you, or she will advise you, of what your rights are in the matter. But it is still your decision as to whether you bring the claim or not and who you bring it against. Once that decision has been made, notice letters in specifically in medical negligence cases, need to be sent out. 75 days thereafter, a lawsuit may be brought, or within that 75 days, a lawsuit may be brought, at which point the lawyer that is handling the case must hire an expert to testify in the case about what the physicians did or did not do correctly. That expert report must be filed within 120 days of your lawsuit being filed, or it's all over. So at that point, once you've gone to that step, you have a lawsuit that you can bring to a jury. There will be a discovery phase where depositions will be taken. You'll sit down with your lawyer, discuss what needs to be discussed with the other side. Your lawyer will be taking depositions of other witnesses in the case and sending out certain written discovery. Then the case will be prepared for trial. During the trial preparation phase, most judges require the cases to go to mediation. And you'll sit down with your lawyer in a conference room with a third-party neutral individual called a mediator, selected by the court, and you'll present your case. Sometimes cases are settled in that venue. If they are not settled in that venue, then the case is prepared further for trial with the appropriate exhibits, witnesses, and so forth. A trial date is selected, and you will go down and try your case. Understand, however, that if you win your case, in all probability, you're going to be on appeal to the Court of Appeals and the Supreme Court. That is, generally speaking, in a very small vignette of what happens in a typical products liability or medical negligence lawsuit.
Well, and I appreciate you giving that succinctly, because I think a lot of people out there, they say, well, you know, they see Law and Order, and I wish a trial would last an hour like Law and Order, but it doesn't. It goes on. It could be years. And remember that, keep in mind, we're talking to a Texas trial lawyer, and some jurisdictions thankfully don't have the tough laws we have here, but it takes a lot to file a lot of resources, a lot of time. You have an in-house doctor, Dr. Wexler, a very fine physician that looks at these cases, so we know that those cases aren't, you know, and there's frivolous lawsuits, more like frivolous insurance actions by passing these frivolous legislative agendas that they had, like House Bill 4. Ladies and gentlemen out there, we've got to wake up and realize that we are giving away the farm. We're losing our trial, our Seventh Amendment right to trial by jury. We're also losing our constitutional rights. We've got to understand that lawyers aren't the enemy. The insurance companies and corporations, they separate a lawyer from a potential client by saying, all lawyers are bad. All lawyers are going to take your money. And doctors believe that too. If you put doctors and lawyers in a room together, can you imagine what we could accomplish? Ladies and gentlemen out there, we've got to understand that gentlemen like Mr. Houssiere, and I get off of my tirades, you know that, but I'm letting people out there know that we're going to be bringing on a series of lawyers, high caliber lawyers like him here in Houston, throughout the state, and throughout the nation that are going to be talking about this. I was going to call up Mark Lanier, a good friend of mine, and we're going to talk about Chinese products. Everybody's worried about that too. Kids can't even, you know, made in China, they're worried about the lead and everything. But in the second half, we're going to talk about products with you. But let's go back. You gave the anatomy of a lawsuit, the medical malpractice lawsuit, and I think everybody now appreciates how difficult it is and how they've made it so difficult. Let's talk about what I like to call the voices of the injured. Now, no names or anything, but I'd like to talk about a particular case that really moved you from coming in to verdict to appeal and getting a positive outcome. I know you've got a newsletter out there. I'd like to just focus in on one case. We've got about 5 minutes left before a break. Could you tell us a little bit about a case that...
I can. Let me just throw two more things out that I wanted to say earlier. There's two areas of the law that I think you should know. One is if you go into an emergency room, those people there at the hospital that treat you, that's not the hospital. Those are independent contractors in all probability, and they will say, if they commit medical negligence on you, that too bad, we are, in this particular instance, immune unless you show that we were malicious in what we did. The other thing I'd like you to know is we trial lawyers are not taking this sitting down. We are filing cases in federal court to hold that that law that was passed by the insurance lobby in the state of Texas unconstitutional
There you go.
as a abridgment of the right to trial by jury.